Trial Tuesday once again, and today we're changing it up a bit and taking your pressing legal questions. Attorney David Aylor, the gifted legal guru, here to give you the answers. So, counselor, welcome back to the show, as always.
Thanks for having me.
Let's get right into this. Cynthia from Mount Pleasant, she wrote on, she wants to know that she recently received a contract from her employer and wants to know how she can get some wiggle room or maybe make some changes to that contract. But of course, with any kind of working situation, David Aylor, she doesn't really want to upset the employer who gave her that contract. So how do you go about that negotiation?
Well, that is a pretty uncomfortable situation, or it can be, because obviously she wants to keep the position or gain the position, but at the same time maybe tweak some things. But what's important is to try to make sure you do that ahead of time before signing the contract. Oftentimes people will try to negotiate after they've already signed a contract. That's difficult to do. And beyond that, probably the thing that I see more often than any other thing is the fact that people do these oral modifications.
Sure.
And then later that modification is nowhere to be found. So you want to make sure, if in fact you do have anything that's changed within the contract, that you do it at a minimum over email, if not just a complete addendum altogether.
So you want to have that physical backup somewhere that you can prove it in a court of law, let's say.
Absolutely. You know, for instance, sometimes it'd say that their lunch break was a little bit longer, or they get a certain amount of vacation days, and, well, my boss told me that. And he or she may have told you that, but if you don't have it anywhere in writing, it's going to be very difficult to prove.
As they say, always get it in writing. When's the best time to do that negotiation? Is it when you get the contract, or is it before they even hand you a physical copy of that document?
Well, sometimes it's better to go ahead and put some things out there, that terms that you're looking for ahead of time. It'll save, you know, the negotiations to the point that maybe if you can't meet on the same page. If not, once you get the copy of, you know, what they want you to sign, the agreement, if you will, then take some time to review it, go over it, maybe even have a lawyer look it over.
Right.
I often look over contracts for people. And then at that point, go back to them prior to signing anything, prior to accepting anything, and of course, starting any position.
So Cynthia, in this case, could go back with that document in hand and say, well, I think I'd like to change this a little bit?
Right, and then just make sure that those changes, even if you initially talk about them, you know, in person, make sure those changes do come out in some sort of form of writing.
All right, hopefully that was helpful. Next question now. Beth from Goose Creek, she wrote in and said she had a roommate dispute. The two of them were friends, and they decided to move in together to cut down on bills. Of course, a familiar story. Things were great for a few months, but then those little irritating behaviors when you lived together began popping up. So Beth wants a roommate gone, but both of their names are on the lease. So I'm sure you see this a lot in your practice.
Absolutely, whether it be just two friends or a relationship that goes sour, boyfriend, girlfriend type of thing. The problem is they're both on that lease, and therefore they're both responsible for that lease. So neither one can move out and not still be responsible, and vice versa. However, if in fact the person that wants to stay is willing to take over the entire lease, then what you need to do is go back to the landlord, because you don't want to be the individual who's moving out thinking that your roommate's going to take over the full payment, then they don't take it over like they're supposed to, and then ultimately it comes back on you and your credit.
Right. What about subleasing? Would that be an option in this case?
Yeah, it could be an option, but it's going to depend on what the actual lease says. A lot of times when you have two roommates, both of their credit and their background checks are going to be run by the landlord. If the landlord's okay with it, which I think the landlord would probably be happy to get the rent,
sure,
then yes, but you want to make sure if you're the one leaving that your name is completely off the lease at the time you leave.
So let's say you already owe money in that situation. Can you go to a judge and try and prove that, or is it kind of still on your onus, your responsibility?
Well, you do see cases like that go to small claims court, and that's why small claims court is such an efficient way to try to handle those things. For instance, if you had maybe an oral agreement and then that you know, roommate went back on it, or maybe you even have it in an email, that sort of thing, you could take that to the court and really try to show it and say, hey, look, here are the damages I had after this person asked me to move out so their girlfriend could move in, or boyfriend, that sort of thing.
Right.
We didn't change the lease. Now he or she hasn't paid, and I'm stuck out a lot of money, and my credit's going bad.
I'm sure it's a very familiar story. We got one last question. A person who wished not to be identified, David. That person writes, messed up on July 4th, got one of those alcohol citations out of the beach that a lot of people were worried about. This person says that it wasn't her. She was just carrying a friend of hers cooler onto the beach when she got stopped by a public safety officer. So they gave her the ticket anyway. Is there anything that she can do, either with her friend or with the police and the legal system, to get out of that $1,040 fine?
Well, first of all, I'm sorry that happened to you, John.
It was not me, I promise.
But ultimately, in that situation, yes, you could fight it. Now, remember, these tickets, even though you're just cited for it, potentially can become criminal records, you know, on your actual permanent record. So the best thing in that situation to do would be to talk to an attorney. You could probably get a criminal defense attorney for a reasonable fee to handle that type of case, and ultimately either try to sit down with the officer, explain it to the officer, or even go to the city prosecutor there in that municipality to try to fight it. Because if in fact, you know, there could be some issues there related to whether or not it was actually in that person's possession as opposed to someone else's.
In a conversation that you and I have had before, you've recommended that sometimes you try and contact that officer directly. Is that something that someone should do in a similar case like this?
You know, it really just depends on who the officer is. Sometimes it's difficult to reach the officer prior to court. So then when you get to court, things move so fast. I often see people pleading to things and really not knowing what's going on.
Sure.
So I would suggest if it's something that's important to you, try to talk with either the officer, and if you can't reach the officer, then sit down with an attorney and, you know, have somebody really walk you through it. Because if you're not used to the system, you know, things can get really confusing. Next thing you know, you've pled to something thinking you've just paid a traffic ticket, and then it's on your criminal record.
Indeed. Great answers to some great questions. If you have any, just hit us up on our Low Country Live Facebook page. Attorney David Aylor, thank you for your time, sir.
Thanks for having me.
Appreciate it as always. Much more after the break. Make sure you stay with us.